Canada's top court says it will hear appeals in a challenge of Saskatchewan's school pronoun law. That law prevents children under the age of 16 from changing their names or pronouns at school without parental consent. The CBC's Mark Carcasole joins us now with more on this story. So can you walk us through how we got here, Mark, and what the Supreme Court's decision today means moving forward?
Well, Andrew, when the government of Saskatchewan passed this law in 2023, its stance was that parents should have the right to know everything that their children are doing in school, regardless of their age. They should know what name their child is identifying by at school, what gender they identify as. Whereas advocates for the LGBTQ2S+ community say that this takes away some autonomy from children at school who perhaps are living a life that is not accepted at home, that this could do irreparable harm to gender-diverse youth. But this issue before the Supreme Court of Canada right now is not to determine who has the stronger take on this particular issue. This is all about the use of the notwithstanding clause, which the province of Saskatchewan used in order to pass this law. Now, we know the notwithstanding clause will allow a government to pass a law that could violate some charter rights. It expires after 5 years. It also protects those laws, once passed, from being struck down by the courts. Now, this case has already been before Saskatchewan's Court of Appeal, and the Court of Appeal found that while it cannot strike down laws due to the notwithstanding clause, courts still can issue declarations of violations of rights, which it did in this case. After that ruling, both parties, the province of Saskatchewan and an advocacy group called You Are Pride, petitioned the Supreme Court of Canada to appeal this, and today we learned that both sides are pleased to hear that the Supreme Court of Canada will hear their appeals. Saskatchewan Premier Scott Moe says, bring it on.
I'm sure they'll be making legal arguments in that particular case. I haven't been briefed precisely on what the arguments are. However, it was their recommendation to appeal it to the Supreme Court. That's a decision then that we made on the advice of the the legal counsel that we have, both in the Ministry of Justice as well as outside. This is a space where Quebec has a lot more experience than us in not only the use of the notwithstanding clause, as they've used it more than all other provinces added up.
Now, Premier Moe mentioned Quebec there because his government was hoping that the Supreme Court of Canada would consider this particular case in conjunction with the case of Bill 21 out of Quebec, which is a bill that prevents public sector workers from wearing religious symbols on the job. That's been before the courts for some time now. At some point, the Supreme Court of Canada is expected to address that. However, it sounds as though they will not hear that appeal along with the case out of Saskatchewan. They will address them separately. Adam Goldenberg is the lead counsel for You Are Pride, the group who has brought this appeal forward to begin with. He says it doesn't really matter to him whether this particular case is heard along with the Quebec case or not. He is happy to hear that it is being addressed individually, though. His concern, again, is the notwithstanding clause overall. He says that governments are overreaching. They're using it far too much now. And in this particular case, he calls the Saskatchewan government's use of it unreasonable and unnecessary.
Clause. If the government really believes that a measure is important enough to use this extraordinary constitutional power, don't you think it ought to believe that it could defend that law on the basis that it's a reasonable limit on charter rights? The fact that they aren't even bothering to do that, in our case, in a case involving the rights of children, tells you something alarming and truly disappointing about the politicians on the political right who have done this. It's cowardly, it's reprehensible, it should stop, but until it does, we will fight them in court until it's over.
So that fight is going to happen. When? We don't really know yet, Andrew. These things often take a lot of time. We're hearing the earliest this may go before the courts is sometime next year, possibly late 2026.
And it's interesting that you mentioned this because there is another province, the province of Alberta, where the teachers union is taking that province to court for, again, saying that they overreached using the notwithstanding clause, that wasn't the purpose.
We're seeing it used more and more and more, it seems, every year. So this is something that Adam Goldenberg and many other lawyers in Canada are concerned about.
All right, Mark, thank you. The CBC's Mark Carcasole.